Hello, everyone. Welcome to another one-on-one discussion for Talking Feds Patreon. I'm here today with Michael Dorf, who's a very eminent constitutional law professor, the Robert S. Stevens Professor of Law at Cornell Law School, and to talk about, a few sort of issues arising from the prospect that the new Republican majority in the House will have a kind of hostage-taking standoff with the debt limit. So first, Michael, thanks very much for being here.
Thanks for having me. Glad to be here.
Okay, I would like to trace through this constitutional argument carefully. I think you've mentioned it's maybe been misconstrued a bit. I wanted to start with a threshold question that I'm hoping you understand, but I'm sorry if I'm hitting you with a surprise, but something you've written suggests you do. So we now hear that we are at the debt limit, and yet there are tricks between now and June or whatever, until we hit the real debt limit. What exactly is that about, the sort of artificial, we can still keep going even we're at the limit, and the real one? Do you have a sense?
Yes, most of that is an artifact of the strange way in which the federal statute that sets the debt limit does so, which is it accounts for gross federal debt, a big chunk of which the government owes to itself. And therefore, by shifting money from some accounts to other accounts, the government can exclude some amount of money from what counts towards the debt ceiling for a period of 5 to 7 months or so, which we're in now. And during that time, therefore, the government can still issue new bonds.
So what's an example of money the government owes itself?
So Social Security Trust Fund is some of that, but there are dozens of ways in which this happens. Mostly they're accounting mechanisms.
Yeah.
And, if you thought that the debt limit served some functional purpose, you certainly would have it count only debt held by the public, not debt held by the government itself.
Okay. All right. So now I think everyone has in mind the basic saber rattling that we have here in the past, with one exception. Parties, there's been a bipartisan consensus that permitting the U.S. to go over the cliff of the debt ceiling would have catastrophic economic consequences, including for our future kind of bona fides as a debtor and the like. But it really does seem as if this crowd is earnest about making it happen. However, let me put it this way first. As there's an elementary distinction that I think you hear repeatedly, and to the good of the media for getting this far, which is, look, the Republicans are saying we can't increase the debt unless we do spending cuts. And the fallacy there is, when you talk about the debt limit, you're not talking about future spending. You're talking about honoring past commitments and just making good on your old debts, as opposed to changing going forward. Now, first, do I have that right? But also, my sense is that fact is of some constitutional import. Is that fair?
Yes. First, let me play devil's advocate for a moment. And I think what the Republicans would say is that while it's true that the past Congresses have enacted appropriations measures, some of those are mere, intentions to pay out money. And, if Congress were tomorrow to repeal Social Security, Medicaid, and Medicare, then some of the money currently slated to go for that kind of spending wouldn't go out of the Treasury. And so they want to characterize the only obligations of the United States as basically principal and interest owed on T-bills.
I see. That's a nice point that I stumbled across in Washington. You pass a bill worth $350 billion, but you haven't done it. Now you go into the appropriations process and you find out how much money there really is to be dispensed and the like. So, okay, that seems like a meaningful distinction anyway, or operatively.
Right. So having made that case for the Republican perspective, I should say that I don't think that is a fair characterization, because the only case that has ever dealt with this issue in the Supreme Court is a case called United States against Perry from the middle of the 20th century, in which the court said that, and this is the constitutional provision you were talking about, the reference to the obligations of the United States in Section 4 of the 14th Amendment is very broad. And so that includes things like promises to pay people for Social Security. And I should say some of those appropriations that are not just, paying off bondholders are what any layperson would consider debt. So, for example, money owed under Medicare to hospitals, doctors, and others who have provided medical services, that's debt. That's the sort of debt one would accrue in a business. And the Treasury just isn't set up to distinguish between what Speaker McCarthy thinks counts as real debt and what he thinks as
Right.
just a kind of aspiration.
Hey everyone, we're taking a quick break to ask you to take a second to like and subscribe. It's a quick thing that really helps the show. Thanks, and back to the video. Okay, well then I think it's worth reading this provision, although you've pointed out people make too much of it perhaps when they at least construe your, and your colleague, Professor, is it Buchanan or?
Yeah, Neil Buchanan.
Who have a theory of the constitutional step a president could take, but it's worth reading. The validity of the public debt of the United States, authorized by law, I think Congress has appropriated, including debts incurred for payments of pensions and bounties for services in suppressing insurrection or rebellion, reminds us it's a post-Civil War enactment, shall not be questioned. And it does. So anyway, that states some kind of important position and seems to give some injunctions for public officials. But I think it's not directly. Maybe we'll return to it, but this is a bit of an arcane argument. I want everyone to sort of be able to see it. So let's set up the hypothetical where Congress drives off the cliff. And we come to the real deadline, and they just say, and Congress, we know this from third grade in Article 1, they're the ones who appropriate money, who spend, who borrow, who tax, et cetera. And they just say, no more. They cross their hands. They're not, they go away. And no more money is to be appropriated at all. So that's what they say. Obviously, it's a crisis. You have in mind. Let's just start with the kind of constitutional analysis before the constitutional solution, perhaps. But in some ways, well, so go ahead. Now you're the president who doesn't want the U.S. to fall into default, and or her advisor. And how would you kind of construe the situation given the acknowledged exclusive powers of Congress to do money stuff as we generally understand it?
Okay, so I'm going to come to the 14th Amendment, right, Section 4 in a moment. But first, I want to analyze this in the way I think it would have been analyzed even before the Civil War, even if there were no 14th Amendment. So as you've just said, Article 1, Section 8 of the Constitution gives to Congress three crucial powers: the power to tax, the power to spend, and the power to borrow. Now, Congress has passed laws that specify how that's going to be carried out, because, of course, Congress passes laws, but then it's up to the executive branch to enforce them. And so what it means to hit the debt ceiling is that the difference between the money collected in the Treasury through taxes, fees, and so forth is not enough to pay for all of the spending that needs to be paid for. Normally, one would then just go out into the market.
Needs to be paid for because it's already been obligated.
Correct. And because there are statutes that say pay this amount. Right? So normally the way you would do that is the government would sell bonds, but you've already reached limits, so you can't do that. So at this point, if you are the president, you cannot simultaneously comply with all three of these sets of laws. You can't unilaterally raise taxes. That's crazy. The president doesn't have the power to raise taxes. You can't borrow in excess of the debt ceiling. Now, what some of the people around Washington will say is, okay, well, just cut spending. But you can't do that either. And I can cite two Supreme Court cases for you for that. One is a case called Train against City of New York, which involved President Nixon's attempt to not pay for a bunch of spending that Congress had appropriated. And the Supreme Court said, no, when Congress says spend the money, they mean spend the money. And that's an important restriction on the president, because otherwise the president would be usurping the power to spend. Second case that does the same thing, also interestingly involving New York, is Clinton against City of New York, where Congress tried to give President Clinton a line item veto,
Right.
and the court said, no, that's not the way it works. So when Congress appropriates money, it can tell the president, here's $100 million, spend as much of it as you need for this, that, or the other thing. But if it doesn't say that, it means spend all of the money. So now he's got what Professor Buchanan
okay, so and that might to do otherwise if he spends 55,000 and decides how to parcel it out. It sounds pretty damn legislative. It's not. I mean, it's not simply that the power is in Article 1, Section 8, but it's like that's what Congress does. Where
exactly right. It's a highly political, quintessentially legislative judgment to decide between spending for this, that, or the other thing.
Yeah.
And so it would be a core violation of separation of powers for the president to say, well, that's your budget, Congress, but I can't comply with all three of these laws, so I'm just going to ignore it and write my own budget, which will be totally different. I'm going to favor my own political friends, disfavor my enemies. That would be impermissible.
By the way, Mike, you keep putting it, I can't comply with all three. I mean, Congress has all three of these powers. Basically, because all three are yours, I have no way out of the box that you've put me in is the notion. No? Or why do you keep insisting on putting it? Okay, go ahead.
Because they're laws. So
okay, fair enough.
Congress, so the president can't comply with all. I'm simplifying. I'm saying, imagine there's a tax law, a spending law, and a borrowing law, right? And they don't add up. Right. So you can't simultaneously comply with all of them. And so what are your options? Well, your options are to unilaterally raise taxes. I don't think that's plausible. It's to make spending cuts, which, as I said, would be big usurpation of legislative power, or to violate the debt ceiling, which I want to make clear would also be illegal and unconstitutional. But, and this is the innovation that Buchanan and I have come up with, we think it would be the least unconstitutional option, because it doesn't involve any real discretion on the part of the president. You're not saying, let's pay for this that Congress has appropriated, but not that. You're not saying, let's raise these people's taxes. You're borrowing.
Nobody's ox is getting gored. You're just trying to meet the deferent that Congress has created. Something like that.
And in exactly the difference between revenue and spending obligations. So there's no exercise of discretion there. You just borrow exactly what you need. And that, in our view, minimizes the constitutional violation. And as you say, because no one's ox is getting gored, you also have the benefit that you're not calling into question the validity of the public debt of the United States, right, under Section 4 of the 14th Amendment. So I want to be clear. I think this is a terrible situation for a president to find himself in. If he were to do this, the markets would probably tank, but I think it would do less damage to the constitutional system than any of the other even worse options.
Well, what about just doing nothing? Just, Congress has the authority here, and does your argument depend on some constitutional obligation, and is now when we get back to the 14th Amendment that, or is it just a general sort of take care, provide for the welfare, et cetera, that require any choice at all rather than sitting on his hands?
Well, I don't think doing nothing exists as an option here, right? Because does doing nothing mean you send out the checks to the Social Security recipients or you don't? So if sending them out is a something, then you've got to have the money to pay for them, and you can only get that by borrowing in excess of the debt ceiling. Otherwise, the check's going to bounce. So you got to do something to put the money in the Treasury. If doing nothing means no, you hold on to, you don't send out those checks, well, that's not a nothing, that's a something. The something is the usurpation of the discretion over the spending.
Okay. All right, so there's no do nothing um possibility. All right, and is that so? There's, am I right? Going to the heart of the Dorf Buchanan insight, it's not as if there exists a principle of constitutional law, Hippocratic oath of least unconstitutional option, but it's just a commonsensical kind of gloss on your guys' part that says if you got to violate the Constitution, try to be as modest as possible. That's not a principle of constitutional law, right? That's just a common sense point of what an executive should or could do. Or am I wrong about that?
I don't think you're wrong, but I do think there's a long tradition of this sort of thinking. The classic example of this is Lincoln's speech to Congress, explaining why he unilaterally suspended habeas corpus, right? Because the Union was in peril, right? He says, must all the laws but one be executed and the Union go to pieces, right? Just so the whole, so I'm paraphrasing and butchering the quote, but that's the basic idea, that this, the phrase that Constitution is not a suicide pact. It's a kind of deep pragmatism that has roots in American constitutionalism.
Okay, I mean, fair, or at least so everyone should be aware of that. You could try to challenge on that ground, but there's been a lot of writing even beyond the American system about Locke and Machiavelli about the sort of prerogative of the executive when you're in these very, very extreme situations. There's a term that's eluding me, but in any event, let me just ask about it practically. Okay, so the basic point, and by the way, you haven't employed, as you say, the 14th Amendment Section 4 at all, and I don't think it's like it's sort of backdrop here, but your submission to some Olympian court somewhere, we'll get to that in a moment, that is not going to include the 14th Amendment, right? Basically,
well, we're sympathetic to the idea. I think the 14th Amendment argument backs up this view, right? Yeah. There is nothing that says, right, the spending or taxing shall not be questioned. It's about the debt. Yeah. And there's no better way to call into question the validity of the debt of the United States than to fail to make payments that are owed. Yeah. So I think it's, we're not against the 14th Amendment argument. We just don't think it's necessary to get you there. And therefore, the people who say, well, the only debt that's real debt is money owed to bondholders or maybe to people who have contracts that are due, we say to them, okay, even if you're right, you still haven't answered the separation of powers objection.
Right. And let me just ask, because I don't know if there's a canonical answer. So this is an injunction that flows to whom? You think of the 14th Amendment as generally constraining the states. But do you take this, and is there an orthodox answer as to who shall not? You and I can question it in your living room. Who can't question it, and does that include members of Congress, or is that also just sort of murky?
So I think the primary addressee of Section 4 is Congress. The worry was
the federal Congress.
Yes. Okay, right. Section 1 is addressed to the states. Section 4, I think, is addressed primarily to Congress, and the concern that historically led to this was that as the states of the former Confederacy had their representation in Congress restored, they would not vote to pay pensions and other money owed to Union soldiers and for debts accumulated by the Union during the Civil War. But you're right, it's phrased sort of in the passive voice. And so therefore, I think it's a command to every government actor.
Okay. So anyway, cutting sort of to the chase, it's really happened. And Dorf Buchanan view really prevails. What step does the executive take? Does he call up the bank and say, how about a few more billion, or how does it work? Or is that kind of terra incognita? So
I think there are two ways it could work. One is you sell the bonds to the Fed. And this is the Federal Reserve holds a lot of government bonds.
You issue. Don't you have to issue new bonds?
Yeah. But you issue them, but then you have to sell them to somebody.
Okay, but you have to. The executive it is the executive who issues bonds anyway, I guess. Yeah.
Treasury, yeah.
Who does right. Okay. So go
Right.
ahead.
So the Treasury issues the
Uh-huh.
bonds and sells them to the Fed, and the Fed credits the account, and so that now there's new money in the government's account with the Fed, and then it uses that money to pay outstanding obligations. I think that's the simplest, cleanest way. But right, there is a risk that Jerome Powell says, "Oh, I don't want anything to do with this. These bonds are illegal," or something like that. You could just auction them to the public. And if you do that, you probably have to offer a fairly substantial interest premium because the legality of these bonds isn't guaranteed. But I think you get takers because I think the understanding would be, well, look, this will get sorted out eventually, and the government will pay.
That's a super interesting point. Now, you'll let's say you get takers, you'll also get lawsuits, presumably.
Well, I'm not so sure about that.
Okay? I don't mean meritorious lawsuits.
Oh, right, yes, absolutely. You'll get lawsuits. Yes, day one you get lawsuits.
Yes, day one you get
probably
lawsuits
in federal district court in Texas.
And maybe this goes afield of your theory, but what's your best guess that the courts and certainly the Supreme Court say no meaningful standards can't not justiciable, be political dispute, blah blah blah?
So first, I'm going to give you my best analysis as a lawyer, like saying what I think the law is, and then I'll predict because I don't think those are the same thing here.
Right.
So I think one of the many virtues of the Buchanan-Dorf view is that ideally no one should have standing to sue. Why not? Well, first of all, unlike the situation in which the president just doesn't pay people who are owed money, here nobody's getting stiff. Everybody who has money owed to them gets paid in full and on time. So they're not going to sue. Yeah. If the Federal Reserve buys the bonds, well, the Fed's not going to sue. And it's not clear that somebody else can sue the Fed saying you shouldn't have bought these bonds. If you sell them to the public, you can sell it along with, a little signature line in agreeing to buy these bonds. I agree not to sue to question their legality. And so you could structure it in a way that should deprive.
And presumably there wouldn't be legislative standing, right? I mean,
because that's very unusual.
But they would bring it, okay.
They bring it. The state of Texas, Ken Paxley would bring it on behalf of the state of Texas. They would sue in federal district court in Texas, and I'm positive that you would find some Trump-appointed judge who would enjoin this program and issue a nationwide injunction, whether or not they're standing or it's a justiciable political question. Supreme Court would then immediately grant review on their shadow docket and schedule oral argument for a day or two later. And who knows what happens then? I'd like to think that they would say, no, we dismiss the suit for lack of standing, but there's no guarantee of that.
Okay. So does this bring us to the prediction part? Was that the law part and now the prediction part?
Right. Okay. My prediction part is that John Roberts has the good sense to lift the injunction temporarily so that, and it's not even clear what's being enjoined, right? Is the government enjoined from this issuing the button? Right. But he lifts the injunction temporarily, sets the oral argument for something like 2 to 3 weeks out, right? Give people a chance to brief. And in the interim, the economic disaster leads Congress to come to its senses. That's my hope anyway.
Yeah. Michael, this is fascinating stuff. And what a mix of high theory and real praxis. Thank you so much for explaining it to us. We'll stay tuned as things maybe get closer to the need for the Buchanan-Dorf view.
Well, let's. I hope that every time one of these crises happens, it's terrible for the country, but somewhat good for my public profile.
For a law professor. All right. So very good. So here's wishing you've got enough prominence as a law professor. Here's wishing this doesn't increase it. Okay. Thank you so much for spending the time. And I hope we can talk again about this.
Great. My pleasure.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.